First of all, the Chief Magistrate's Court, which was read upon by my colleague Birivumbuka, the Magistrates Act, my lord, I don't know which act he quoted because he never put the cap. But whatever it is inapplicable here. However, even if, my lord, the court was of the view that we can borrow the provision of the Chief Magistrate's Court for community purposes, the section which he actually quoted, section 168(2), is not in his favor. He was talking about the name, but allow me to read this section. The summary of the case referred to in subsection 1 shall contain such particulars as are necessary to give the accused person reasonable information as to the nature of the offense with which he or she is charged. My lord, we are not aware of the new amendment of the Magistrates Court Act and the subsection 2 which talks about the name. As far as we know, my lord, the offense with which, or the offenses with which F3 is charged were able communicated clearly in the charge sheet and in the indictment. And the name. So, my lord, that subsection also sees of the redundancy of the submissions of counsel for L3. I'll divide this court to this.
My learned friend referred to you cited some authorities. I would like also to refer you, my lord, I would like to refer you to this authority about fair trial, Uganda Law Society. It's a constitutional Uganda Law Society versus, and another, sorry, Jackson Kagaba versus the Attorney General. It's constitutional petition number 2 of 2002. They were consolidated, there were 2. Constitutional petition number 2 and 8 of 2002. My lord, the fundamental issue in this particular case, the bone of contention, was that, and this is what the court said, the gist of the argument is that the trial was too speedy, that it was not possible to give the accused persons the safeguards they were entitled to under the law. This was the trial of Corporal Medio and others who were subjected to trial, summary trial of 3 hours, and shortly thereafter executed in the Karamoku. And the Constitutional Court had the occasion to revisit this matter, and specifically on page 17, made the following finding. The issue is whether this was a fair and speedy hearing envisaged in Article 28(1) of the Constitution. In order to understand the meaning of this mandatory requirement, we have to look at the relevant provisions in the World Constitution, but also the entire provisions of Article 22, 28, and 44C of the Constitution. can what is required to be done under those articles be accomplished in a matter of just 3 hours? Sure. When considering the requirement of a speedy trial, speed must be measured against the requirement that the trial must be fair in all other aspects spelled out by the Constitution. And they concluded by saying that speed must be reasonable. Speed and reasonable speed must be measured against the overall objective of achieving the fair trial. In my opinion, this trial was not conducted in accordance with Article 28. The process was a clear contravention of that act. My Lord, notice at all was, is there notice? No. There was no service. Oh. And there was no, even they had no courtesy of asking for leave of court to serve out of time. My Lord, the court orders are not made in vain. The order to serve within 10 minutes was a court order. So there was no notice to begin with. There is no notice. There is not in service. And that is a violation of Section 61 of the TI. Because that must be served. It has not been served.
We had put this court and accused persons on notice that we are going to make amendments. Regardless of whether there was an order by this honorable court or not. And as such, my Lord, yesterday we made the amendment, my Lord. We are surprised by counsel for accused persons. Probably they thought prosecution is like a robot. Do this, you do that. We know what to do. And that's why we made that amendment. So it is not therefore true, as put by my senior colleague Mr. Panda, Fred as it is now, that the prosecution indeed knew outcome of the ruling, and therefore we amended before. That was speculation of the highest order, and it should be condemned to the contempt